panel for the third crisis on chemicals, waste and pollution prevention. And in the lead up to the establishment of this science policy panel, this series of webinars and events that kicked off in April aims at building bridges and promote collaborations and knowledge sharing between and among stakeholders, and to raise public awareness, preparing proposals for the establishment of the panel. These events have been organized in the margins of major negotiations or as direct discussions that could contribute to the development of documents and proposals for the second session of the Open End Working Group. Today's webinar aims to take a deep dive into procedures employed under existing science policy interfaces to address potential conflicts of interest, the reflections and lessons learned from the experts with the first-hand experience with existing procedures that have joined us the panel today will help feeding this process. This event will indeed inform and prepare member states and other stakeholders for the discussions of this substantive matter later this year. The event will be moderated by Ms. Tessa Goverse, who is leading the ad hoc Open and Working Group Secretariat team. And before I hand over to Ms. Goverse, let me, and you are formally welcome to this event, let me remind to all our attendees that the documents, the video and summary will be made available on the website, and you can find the link on the screen or in the chat. And throughout the event, you can raise your questions by using the Q&A box, and we have a dedicated session to address this. And finally, let me also add, as you can see on the screen, that the transcription is available at the bottom left of your screen in over 100 languages. With that, Ms. Goverse, over to you.
Thank you so much, Diana, and thank you so much to the Geneva Environment Network and everyone else who behind the screens have helped to organize this important webinar on procedures for addressing conflicts of interest, lessons learned from existing science policy interfaces. My name is Tessa Goverse and I will indeed be moderating today's event. And as Diana mentioned, I'm heading the Secretariat of the Ad Hoc Open-Ended Working Group on a science policy panel to contribute further to the sound management of chemicals and waste and to prevent pollution, in short often referred to as the SPP OEWG. The Open-Ended Working Group is mandated by the UN Environment Assembly under Resolution 5/8 to develop proposals for establishing a science policy panel on chemicals, waste and pollution prevention. And as we are preparing for the establishment of the panel, we carefully look at examples and approaches taken in other science policy interfaces, including how to address conflicts of interest. The Open-Ended Working Group has a total of 3 sessions to complete its work. And while the future panel is still under negotiation, conflict of interest policy is one of the substantive matters to be discussed at the second session of the Open-Ended Working Group, which will take place at the end of this year. It's therefore a great pleasure for me to welcome you all to today's webinar and to welcome not only the chair of the Open-Ended Working Group who has joined us here in Nairobi, but also the esteemed representatives of key UN entities and science policy interfaces. Today's webinar aims at taking a deep dive into procedures employed under existing science policy interfaces to address potential conflicts of interest by inviting reflections, lessons learned, those things we can really learn from those who have the first-hand experience with the existing procedures. So with that, I have the great honor to introduce the chair of the Open-Ended Working Group on the Science Policy Panel on Chemicals, Waste and the Prevention of Pollution, as well as the Deputy Permanent Representatives of the Netherlands to UNEP, Ms. Goody Alkemade. The floor is yours, Goody.
Thank you, Tessa, and thank you also, Diane, also for your introduction, as well as the rest of the Secretariat for making all the arrangement. It's colleagues, ladies and gentlemen, it's a great honor and pleasure as the chair of the Open-Ended Working Group to welcome you to today's webinar on conflict of interest policies. I would like to extend my thanks also to WHO, the IPCC, and the Ocean Secretariat, the Office of the High Commissioner for Human Rights and the Geneva Network for their support in the organization of this webinar. I also would like to thank our distinguished panelists for participating in this webinar, despite their busy schedules, and I know quite well how busy it is in this year, and most likely next year as well. At its second session, the open-ended working group will engage in substantive discussions to make proposals for the establishment of a science policy panel, in particular on the issues outlined in paragraphs 5 and 6 of UNIA Resolution 5/8, where conflict of interest policies will be one of the issues that will be discussed. In the realm of science policy interfaces, maintaining the integrity of information and decisions is paramount, and understanding and implementing effective conflict of interest policies is instrumental in ensuring the legitimacy, the credibility, and the inclusivity of the process. It is my hope that this webinar will help to provide you, member states, and stakeholders participating in this process with practical insights and strategies of how potential conflicts of interest may be identified, assessed, and mitigated in science policy interfaces, so to foster a culture of trust, credibility, and inclusivity. We have with us today several esteemed experts with extensive experience in different science policy interfaces who can share their valuable perspective on the challenges and best practices associated with addressing potential conflicts of interest in the context of science policy interfaces. As we navigate through this session, we encourage your active participation and engagement through the Q&A and chat functions, as was just introduced by Diana, as your questions and perspectives will be vital in comprehensively addressing the topic of potential conflicts of interest in the context of our work ahead. Without further delay, let us start the discussions as we move toward fostering a strong science policy panel underpinned with robust science and a steadfast commitment to address conflicts of interest with the utmost integrity and diligence. I thank you.
Thank you very much, Goody, for your opening remarks and encouragement and stressing the importance of this topic from the onset. So, as you urge us, let's dive straight in, and we will now proceed with a short presentation from the Secretariat on the conflict of interest topic. Mr. Richard Miesen, you have the floor.
Great. Thank you, Tessa, and thank you, Goody, for your opening remarks. My name is Richard Miesen. Good morning to everyone, afternoon and evening. I'm a project management officer with the OEWG Secretariat, and today I'll be providing some background information on the procedures for addressing conflict of interest. To prepare the working and information document for open-ended working group number 2, the Secretariat has conducted a desk review of some of the existing science policy interfaces and their conflict of interest policies and procedure. If you could please go to the next slide. These include the Intergovernmental Panel on the IPCC, on climate change, the Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services, Global Environment Outlook, the Montreal Protocol Assessment Panels, and in particular, the Technical and Economic Assessment Panel and the World Health Organization. But before we jump into some specifics, let me set the scene. Actually, if you could go back to the previous slide. Just a little bit of the background on how we got to this discussion today on conflict of interest. So as Diane had referenced, at the 5th United Nations Environment Assembly, member states decided via Resolution 8 that a science policy panel should be established to contribute further to the sound management of chemicals and waste and to prevent pollution. Further, in the resolution, paragraph 6 highlighted the need to ensure that the panel has the ability to address potential conflicts of interest. At the resumed first session of Open-Ended Working Group 1, which was held in Bangkok, member states had an opportunity to discuss some of the key aspects of the future science policy panel and key issues to be considered at the second and third sessions of the Open-Ended Working Group. At the meeting, an understanding was reached that several issues would be taken up as appropriate in the documents to be developed for the second session of the ad hoc Open-Ended Working Group, including on the conflict of interest. So in preparation for the second meeting, the Secretariat has prepared a working document which discusses conflict of interest and which will be supported by an information document with additional information on the existing conflict of interest policies. As mentioned by Ms. Alcamade, it is expected that initial discussions on conflict of interest will take place at this meeting planned for December. Next slide, please. So as I began to introduce, we have prepared a working and information document following a desk review of some of the existing science policy interfaces and their existing conflict of interest policies or procedures. These include the IPCC, the IPBES Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services, the GEO Global Environmental Outlook, the Montreal Protocol Assessment Panels, and in particular, their Technical and Economic Assessment Panel, and the World Health Organization. Next slide, please. So what exactly is a conflict of interest and what does it do? The ability to address potential conflicts of interest is a key component of legitimacy, independence, and credibility of science policy interfaces. The purpose of conflict of interest policies in general is to protect legitimacy, integrity, credibility, transparency, trust, and independence of their associated interface. These policies define what constitutes a conflict of interest and to whom the policy would apply to. I'll go into more detail in one of the next slides on this. Conflict of interest policies also define to whom the policy will apply. Of the policies examined, this would typically include senior leadership, members of subsidiary bodies, and those who are involved in the production of deliverables, in addition to the Secretariat staff. The wide application of the policy is also important given that, according to Resolution 5/8, the Open-Ended Working Group should take into account the need to ensure that the panel is interdisciplinary, ensuring contributions from experts from a broad range of disciplinary expertise, has inclusive participation, and it is anticipated that a wide range of experts from around the world will be engaged to help deliver its work program. Some of the existing conflict of interest policies establish a dedicated group to address potential conflicts of interest and implement the policy itself. Conflict of interest policies establish a procedure for when actual or perceived conflicts of interest arise. This process typically includes the submission of a conflict of interest disclosure form, generally made available online, to the previously mentioned dedicated group. This group is sometimes called the Conflict of Interest Committee. Identifying a conflict of interest does not necessarily mean that a conflict of interest exists. Where conflicts are identified, the relevant body will try to resolve the conflict in consultation with the individual in question. In general, if a conflict of interest cannot be resolved, the subject of that conflict may not be eligible for appointment to a certain position or may need to be recused from a defined area of work. To give you an idea of what types of conflicts are covered by these policies, they could include financial conflicts of interest, professional, which could mean employment relationships, consulting arrangements, intellectual property interests or sources of research support, or past or potential future conflicts. But there is variation as to how this is defined amongst the various policies. Next slide, please. A review of the existing policies from some of the existing science policy interfaces has illuminated several similarities amongst these policies and of the existing science policy interfaces. For example, with respect to purpose, the protection of legitimacy and integrity are themes that emerge out of most of the existing conflict of interest policies. But in general, all of the existing policies utilize similar language to express the importance of trust, transparency, confidence, or credibility of the interface. Similar language for the scope is also observed among these policies with respect to who it applies to. In general, as I had mentioned previously, it will apply to those in leadership positions. This could include chairs, co-chairs, bureau members, or task force members. could include members of subsidiary bodies, such as working groups or co-chairs of multidisciplinary expert panels, members of multidisciplinary expert panels, and it also applies to those who are involved in the production of deliverables. These could be assessment co-chairs, coordinating lead authors, contributing authors, or review editors, to name a few. And of course, it also applies to the staff members of the interface itself in the Secretariat. The exact language for the definition used by existing bodies is also very similar. We're presenting now on the screen the definition used by IPBES, which states that a conflict of interest refers to any current interest of an individual that could, A, significantly impair the individual's objectivity in carrying out his or her duties and the responsibilities for the platform, or B, create an unfair advantage for any person or organization. I highlight here in bold the platform, just to note that these points under A and B are actually observed nearly verbatim in IPBES, IPCC, the GEO, and the Montreal Protocol Technology and Economic Assessment Panel policies. So we see a high level of overlap in the definition used by all of these entities. In general, as I previously mentioned, the existing interfaces establish an advisory body to oversee the implementation of the policy. The name differs from entity to entity. Some will call this a conflict of interest committee, others a conflict resolution advisory body, or they may delegate the authority to the Secretariat, which is the case of the GEO. While noting all of the similarities that these existing policies show, there are some differences among the existing policies as well. One such example is coming from the Technology and Economic Assessment Panel of the Montreal Protocol. In this case, they post declarations of potential conflicts of interest online, while the other faces do not make the declaration forms available to the public. In addition, some examples include the language which refers to the significant financial interest of close family members and not only of the individual in question. Next slide, please. So with that, I'd like to say thank you for your attention. We note that the official meeting documents are not available online yet, but will be made available soon. Thank you for your attention, and I'd give the floor back to Tessa.
Thank you so much, Richard, for this presentation. And we will now turn to the panel discussion with very distinguished speakers today from the existing science policy interfaces. As an audience, you also will have the opportunity to engage later on in a Q&A session. You can also, meanwhile, post questions in the Q&A box in WebEx. It's then a great honor and pleasure to introduce Professor Jim Skier. And Jim, before introducing you further and giving you the floor, warm congratulations on your election as the chair of the IPCC's 7th assessment cycle. It's a great honor and pleasure to have you with us. You've been with IPCC for many years, and you've been co-chairing Working Group 3 on climate change mitigation. Could you perhaps briefly introduce yourself and give your thoughts on why you think it is important to address conflict of interest under science policy interfaces? Your initial thoughts on the matter, please. The floor is yours.
Okay. Thanks very much, and thanks for inviting me to this. It might be worthwhile reflecting on why IPCC had a conflict of interest policy in the first place. And if you remember the days around 2010 of Himalaya Gate and email issues around IPCC, the issue was referred to the Inter-Academy Council, which makes up the scientific academies of various countries, to conduct a review of IPCC processes and make some recommendations about innovations. And part of their recommendation was to establish a formal conflict of interest policy, as well as processes for dealing with, for example, alleged errors in IPCC reports. Now, as part of the history, just to say, I was a vice chair of Working Group 3 at the time, and I was actually appointed to act as rapporteur for the task group that developed IPCC's conflict of interest policy. So I kind of know where the process started. And I have to say, I spent more hours on the telephone with US State Department lawyers than I would ever have wanted in the process of actually putting that conflict of interest policy together. So I saw where it came from later in the fifth cycle. As a vice chair of IPCC, I was kind of the enforcer for the conflict of interest policy. And of course, in the last cycle, AR6, I was responsible for running it in Working Group 3, which is probably the working group within IPCC that has the biggest analogy with the new assessment process that's being set up. There are a mixture of commercial, academic interests in that area. So just to say, in developing the policy, one of the things that we debated quite a lot was the rigor of the policy. And just to say, IPCC's parent organisations are WMO and UNEP that both operate under the UN system. And there was an inclination on their part to base everything on the UN ethics policy to which all employees are subject. There was a great nervousness within the task group that the rigor of these ethics policies, which were intended for employees and for a different purpose, could actually put off people participating in IPCC if it was perceived to be too rigorous. So there was a debate about the rigor of the policies and the degree to which it would continue to engage volunteers to support IPCC activity. The other thing that I would flag up is we're very careful to distinguish between bias and conflict of interest. Simply having an opinion is not enough. And also to carefully distinguish between potential conflicts of interest and then the process by which they're examined to see whether they turn out to be actual conflicts of interest. You've obviously you've done a thorough job in reviewing what the actual procedures say. So maybe I can talk just a little bit more about how it kind of operated in practice to get a sense of that. One thing that we make very clear is that the policy is applied more rigorously the more senior the person is within the organisation. So for example, if you're an author and you're doing one particular part of a chapter in IPCC, the standards would be applied less rigorously because there are other ways of dealing with that within an author team. Whereas you get to working group co-chairs, vice chairs, and the chair of IPCC, the process has to be applied more rigorously. So essentially, I personally have limited anything that could be considered to be a potential conflict of interest. In terms of the kind of issues that have come up in the IPCC's conflict of interest policy in talking about specific cases, I think I would flag up three areas in which there have been sensitivities. One is if IPCC authors or bureau members also have a role within other UN bodies or government initiatives, like being part of a delegation to the UN Framework Convention on Climate Change. We have really tried to avoid that and to say that that is a conflict of interest. It is also a case, it's a bit marginal, but if people are involved with other UN organizations whose activities are adjacent to climate change, we've thought about that quite carefully, not necessarily being precluded. And worthwhile, some of these organizations have forbidden their employees to participate in IPCC because it's perceived to be a conflict of interest from their perspective rather than from our perspective. So the question of other international bodies, membership of government delegations is an issue. One that has come up a lot with our academics is the question of holding editorial roles in key journals, which might be judged to be gateways to the scientific literature. And I think that's something that's varied quite a lot. Mostly people, say at Working Group Co-Chair, have recused themselves from such roles because they perceive there would be a conflict of interest in terms of acting as a gateway for scientific research into the accessible literature. I think that depends where the science is. There are some areas of science and some journals that are absolutely key to the literature because of the high esteem in which they're held. There are other areas in which there are many, many journals out there, and I don't think you could really say that having an editorial role is it allows you to influence the state of the literature. And the final area, of course, is in relation to much more commercial relationships, employment, whether people have other kinds of financial interests that might be of relevance there. And can I just say that this is going on to the implementation issues. Our policy is largely silent on what to do when a conflict of interest is actually identified. It's very good on identifying them, it's less good at saying what you should actually do when you got there. But there is a quote that says, in exceptional circumstance, a conflict of interest on the part of an author which cannot be resolved may be tolerated where the individual is deemed to provide a unique contribution to an IPCC product, etc. And one of the things that, you know, when things have been referred up to our conflict of interest committee, I have to say it has taken in general a fairly liberal view of what to do to manage a conflict of interest, being very reluctant to exclude people completely from the process. And it's much more being resolved by asking people to be transparent about what their interest is and declare it to fellow members of the author team, and if necessary, remove people from that particular part of a chapter where the conflict of interest might be deemed to arise. But in general, a fairly liberal view is taken. Can I flag that there is only one case I know of where somebody was actually actively removed from an IPCC role because of conflict of interest, and I know all about it because at the time I was the hitman, as it were, for Working Group 3 that had to execute it in the fifth cycle. And the particular issue arose because the individual owned a startup company and owned patents and intellectual property that directly conflicted with the contribution to the IPCC assessment. And the individual concerned was quite open about it, and when it was discussed with the person, they stepped away from the actual process. It's the only one that I know of. We do have authors from the business sector. We have authors, for example, from oil and gas companies in Working Group 3. We have had authors from insurance companies and infrastructure, architectural firms in Working Group 2, concerned more with adaptation. And in general, they've played a relatively limited role, and these positions have been tolerated on the grounds that it is perfectly transparent where the people are coming from effectively, and they have not played a critical role in the chapters where it has touched on the interests of their employers. I have to say I feel a little unease about that, in that we are tolerating commercial relationships with very large companies and multinationals, but we came in heavy on the small startup company where actually there was a more focused and identifiable conflict of interest that arose. So I think that's probably about all I could say. I thought I would focus more on the practical issues of implementing the policy, because I think the interpretation of the policy is at least important as what is written down on a piece of paper. And just to say, IPCC needs to review its principles and procedures in the coming cycle, and it will be up to governments to decide whether or not the conflict of interest policy needs any revision or not. My view is that it is working at the moment, and it is not causing any great difficulties in terms of the operation of IPCC. And I haven't heard any suggestions that our work has been compromised by the way the policy has been implemented, but I'll stop there.
Excellent. Thank you so much for very rich reflections and indeed also talking how policies actually work out in practice and giving your view of how well that has worked so far. Very much appreciated. I would like to then turn to our next panelist, Ms. Marta Pisano. She's the co-chair of the Technology and Economic Assessment Panel, the TIAP of the Montreal Protocol, and co-chair of TIAP's Methyl Bromide Technical Options Committee. Marta, you have co-chaired TIAP since 2010. You must have come across some interesting examples and experiences as well, and perhaps also some evolution in the thinking around this. Could you also briefly introduce yourself and give your take on the matter of conflict of interest?
Yes, thank you very much, and good morning, afternoon, or evening, whatever the case may be. It's sort of early morning for me at this end in Colombia. Yes, like you said, I have been a co-chair of the TEEP, the Technical and Economical Assessment Panel, since 2010, and of the MEPTOC, the Methyl Bromide Technical Options Committee, since 2005. So yes, the years have gone by, and we have encountered many issues. I was very interested in hearing Professor Ski's description, because I find a lot of common ground as to how we address conflict of interest. This has indeed been a topic that we have worked on very carefully. We went through a very detailed process of reviewing our TOR, our terms of reference, I must say about 10 years ago, when we even, a task force was set up. We even had a lawyer with us, and we went through like every possible conflict of interest situation that could arise. And what prompted this was that, in fact, we did have some problems even with the TEEP co-chairs and the membership. So this really moved things forward. On top of what we have heard this morning, I would like to say we do have this declaration of interest forms that we've worked on. These are shared with all members, whether or not just members of rank, but also co-chairs. Just as a parenthesis, TEEP brings together at the moment 5 technical options committees, and they deal with quite different aspects of the Montreal Protocol. There will be methyl bromide, there will be halons, foams, refrigerants. At the moment now, refrigerants is a very big issue with our Kigali Amendment, etc. I won't go into that. But this brings together, I would say, about 150 members altogether for all technical options committees. TEEP is composed of the co-chairs of those committees, plus some senior experts, which bring into the TEEP expertise that we would not otherwise have. For example, people who are very, very familiar with how the protocol works and what its bases are, or people who are modelers and can take the information arising from technical options committees and turn them into trends and models, etc. So it's a very diverse population, if you like. So the first step when you join one of these groups, and this can also include subsidiary groups that are formed temporarily to address specific issues, is that you are briefed as to what your role is. You are there as an expert, never as a country representative. We really do try to keep the politics out. And this is something that sometimes we find it difficult for parties themselves to understand, because that is another important issue. Who can nominate and how can a person get onto these committees? So in the case of TEEP, it's only parties that will appoint. In the case of committees, the co-chairs can also appoint. That said, the TEEP co-chairs can appoint or suggest a member. But in any of these cases, the party has to be consulted, informed, aware of this member joining in whatever capacity. In order to join and to participate in any meeting, you have to fill a declaration of interest. And as we heard at the beginning, these DOIs are actually online, they are public. This DOI form includes information on what your work is, who you work for, what your next of kin do. Do you hold shares in a big company, for example? Do you work for research institution, etc.? Declaring this does not mean you are conflicted, of course. It just provides background information. But I would like to stress on what Dr. Ski mentioned about it's not only the conflict, but also the appearance of conflict that is important here. And also very important, you can have your opinions, you know, you can be strongly inclined towards one end or the other. That doesn't mean you are conflicted. Sometimes it is difficult to make people understand that this is the case. And of course, we do try to avoid, shall I say, animosity between, you know, members of all these scenarios. You know, just because you declare, it doesn't mean you're going to be, you will have fingers pointed at you or be considered as difficult or something like that. I also wanted to refer to the fact that we have a code of conduct. You know, when we are saying that we are striving for transparency, credibility, yes, definitely. But there is also a code of conduct. And we have had over the years problems with this, you know, people who really want to impose or an agenda or something like that. When I refer to a very varied audience that we work with, yes, we have members who are scientists, industry members, consultants as well. So everybody could have a special, I don't like to use the word agenda, but everyone will have a specific interest in being there. And on top of all this, we are all volunteers. The Montreal Protocol does not pay any of these members except for travel and accommodation for what we call A5 members. A5, Article 5 is a division within the protocol that largely involves developing countries. If you come from a developed country, your own country or institution should fund you for attendance. We are finding big problems with this nowadays, especially on topics that are not as critical at the moment. For example, methyl bromide was very critical years ago. It is not so anymore. So countries are not as willing to fund their members. And we have members who fund themselves. You know, I'm always amazed for that, you know, that they come out of pocket to just, I guess you develop a passion for these topics, which is hard to explain, but look at me, I've been there for years and years. Anyway, we do have some guidelines as to what to do when a conflict arises. So there are different levels. For example, let me give you a very easy example. You have a member who is a researcher, and this is a real case, who is a research on methyl bromide issues, belongs to the methyl bromide committee, and the specific case that is being assessed or evaluated could impact funds he or she receives for this research program. So the ideal would be for that member to recuse himself or herself. If that does not happen, the co-chairs have the power to recuse a member. It's not pleasant, but it can be done, and it's actually in the tour. Sometimes we go as far as having members from a certain country recused because a specific scenario is being evaluated involving that country. So I would say that is not a requirement, but it looks better. Transparency and credibility are enhanced. So that could be a case. But just to say that members themselves can recuse, even if the rest of the committee and the co-chairs do not feel it's necessary. Or they can be recused by the co-chairs if that were the case. There is also provision for, shall I say, like stronger conflict of interest that will go up to a committee or a group of wise persons, is what they are called within our TOR. Three, I think it is three at the moment, persons who are selected to evaluate that case, if it's brought up or scaled up to that position, and the president of the parties of that particular year will also participate there. Again, like Professor Ski was saying, this is not a pleasant scenario, but it's still something that there is provision for in the terms of reference. And it's always very useful to know what you should do if this arises. What is the process? Something I forgot to say, if as a member or co-chair you have not filled your declaration of interest and have not submitted it for the Ozone Secretariat, you cannot participate in meetings. You know, it is a requirement for you to sit down at a meeting, no matter what level it is. We also are very strongly against having members who are parts of delegations. We feel that in itself is a conflict of interest. Maybe in the past we had members like that, but presently we will not allow a member who is also a part of a delegation. I don't believe we have gone as far as part of another convention of UNEP. I believe the protocol is so absorbing that it's very strange for or rare for people to be there. And that said, I'm so happy to see Guri again, because I had lost track of you, Guri. So it's very nice to see where you are, and congratulations. And that's very fine to know that you are still working for a common cause. I think pretty much that's what I had to say, and I'm very happy to answer questions if I forgot anything. I also have with me my co-chair, Ashley Woodcock, who has a different view because he's a physician and he has been very involved in the medical side of the Montreal Protocol. If we have time now or later, maybe Ashley can intervene and add to what I said. For now, that's all. Thank you.
So much, Marta. That's really excellent, and indeed, as you started off saying, a lot of common ground as well. But very, very good to understand more about how the conflict of interest policies, procedures are put in practice under the Montreal Protocol. And yes, if time allows, we would be very happy to hear from your colleague or yourself during the Q&A session.
I guess just before I go, I forgot something very, very quick. We reach all our recommendations by consensus. I think this is really important, right? There's never any vote, but it is consensus, and that is a skill that the co-chairs of any committee or the TIP itself need to develop, you know, how to manage consensus being agreeing not to disagree. That, just leave it there.
Thank you very much for that addition. So without further ado, I would like to then turn to Ms. Kate Robertson of the World Health Organization. Kate, you've been a legal officer over the past years for the Public Health Law and Policies Unit of the Department of Health Promotion. Could you also briefly introduce yourself and have your initial thoughts on conflict of interest procedures and why they are very important in the context of your work? Kate, the floor is yours.
Thank you very much. Good morning and good afternoon and good evening to everyone, and thank you for having me. It's great to be part of this very high level and very interesting panel. I suppose just to start, to consider conflict of interest from the perspective of WHO. So WHO is a directing and coordinating authority for health within the UN system. And so it has functions and responsibilities, including shaping the health research agenda, setting global norms and standards, articulating evidence-based policy options, and providing technical support to countries, all of which are based on the collection and analysis of data and on reliance on the best available science. So addressing conflict of interest is an important issue, not just for a specific science policy panel, of which there are a number within WHO, but also for WHO's work more broadly. Looking specifically at the science policy interface, including at the most recent World Health Assembly, there was a recognition of the importance of reliance on the best available science and risk-based assessments to inform the development and implementation of policies to address public health issues. So basically, to ensure that these policies are well supported, that they're going to be trusted, that they're going to be implemented effectively and fairly, it really is important to avoid potential bias, misinformation, any actual or perceived conflict of interest, as well as to ensure the quality of the scientific and technical analysis and advice that's been given by that panel or body. Because conflict of interest has the potential to unduly influence policy, and because an actual or a perceived conflict could actually compromise the integrity and independence and credibility of a panel, which has been addressed by a number of other speakers, it is really important in that context that conflicts of interest or potential conflict of interest, I think it's important also to differentiate between those terms, are appropriately disclosed, identified, and either managed or avoided. Just to speak briefly to the broader WHO approach to conflicts of interest. So WHO has a framework for engagement with non-state actors, which doesn't just include commercial or private sector actors. It's really anyone who's not a state. So looking at NGOs, looking at academia, it basically guides the interactions and the engagements of the organization with non-state actors in a broad sense. Essentially, under FENSA, as it's known, there are some quite strong principles of engagement, which are a helpful guide, I think, to the considerations that need to be had in putting together any particular engagement. And particularly, one of the principles is to support and enhance without compromising the scientific and evidence-based approach that underpins WHO's work, and also not to compromise WHO's integrity, independence, credibility, and reputation. So with the FENSA approach, it looks not just at individual, but also institutional potential for conflicts of interest. And also importantly, it looks at a risk and benefit kind of analysis. So looking at what the benefits might be of a particular engagement. And there are many occasions on which, and again, previous speakers have alluded to this in different ways, in which public health can be assisted by input from non-state actors. There are also risks, and one of the risks identified is conflict of interest. So the general process proposed under FENSA for conflict of interest is not just, is to actually for WHO to undertake a due diligence exercise. So not just to look at what is produced, but also to inquire a little more broadly. I mean, particularly where you're looking at institutional engagement. And by institutional engagements, I mean also funding arrangements, partnerships, co-hosting arrangements, that sort of thing. Also to undertake a risk assessment and to have a coherent communication within the organization across all three levels about the risks and the way they're to be managed. Also, an important part of management is to ensure that there's oversight, that there's transparency over the engagements that are undertaken, the people who are engaging with, and also that there's the opportunity for member state oversight of the various engagements that WHO undertakes. Importantly also, internal WHO policies need to align with FENSA, and particularly relevant in this context, the regulations that WHO has in place for expert advisory panels or committees, guidelines on declarations of interest for WHO experts, staff rules and regulations, obviously, as well, regulations for study and scientific groups, and also financial rules and regulations. Importantly as well, and just as a final point, the FENSA acknowledges that there are a number of different types of engagements, and that some engagements from a public health perspective will never actually be acceptable. So for example, under FENSA, there is no engagement by WHO with the arms industry or with the tobacco industry or those representing its interests. Basically for the reason that those industries, being the sale of lethal products, have a fundamental and irreconcilable conflict of interest with public health, and therefore engagement for WHO is not possible. However, it also acknowledges that there are a range of different ways in which engagements might be relevant, and also different sort of stages and different ways and different contributions through which a conflict of interest, once identified, might be managed. I think I'll stop there and perhaps hand back to you, to other panelists. Thank you.
Great, thanks very much, Kate, and very interesting and detailed how the conflict of interest or the potential, as you rightly point out, it's a very important distinction, is dealt with and institutionalized within WHO. Next, it's my pleasure to welcome Mr. Marcos Orellana, UN Special Rapporteur on Toxics and Human Rights. Marco, we were together in a Geneva Toxic-Free Talk event a couple of weeks ago, which built on your 2021 report on right to science in the context of toxic substances. And actually the issue of conflict of interest also came up with so many words during the event. Can you also briefly introduce yourself and share your thoughts on why it is so important to address the matter of conflict of interest under science policy interfaces? The floor is yours, Marcos.
Thank you very much, Tessa, and thanks also to the Geneva Environment Network for the invitation to join this conversation. As you rightly pointed out, a couple of years ago, I had the opportunity to report to the Human Rights Council on a thematic report on the right to science, which addressed the critical importance of science policy interface platforms. It talked about, for example, the need for a science policy panel in chemicals, wastes, and pollution in order to advance on, inter alia, the right to science. The right to science for many years has been a rather neglected right in the catalog of human rights instruments. But already, as we celebrate 75 years of the Universal Declaration of Human Rights this year, the right to science figures in that instrument, and then later codified in the International Covenant on Economic, Social, and Cultural Rights, and among other instruments at the international level. There's so much that could be said, but in short, the right to science in context of chemicals and waste requires alignment between protections, between regulatory measures and the best available science. That is why such importance of science policy interface platforms to enable the dialogue and that alignment. But in reality, what we see is a wide distance between what we know and what we do about it. And this distance has the result of exposure of countless individuals and groups, which has a negative and adverse effect on the enjoyment of human rights. Where does this disconnect come from? Why does this wide distance exist? Well, there's three elements at least that I wish to highlight today. One is disinformation. So product defense firms, or sometimes called conflict scientists or mercenary scientists. So scientists for hire, firms that specialize, whose business is to spread doubt, to spread confusion, so that there's paralysis and the democratic systems are unable to act. That's a big one, of course. Then there's also, as documented in my report, attacks against scientists. I document situations where scientists that have come out with certain studies have been attacked in their funding sources. In some countries, I've documented how the boards that define or that approve certain funding trajectories are composed with members of industry, and so they have blocked any studies that could impinge on their interests, for example, on pesticides. There has been number of cases on attacks against science on university promotions, for example. There's also cases where scientists have been harassed in court by criminal proceedings or civil proceedings. And then a third reason that explains the distance is conflicts of interest, where science policy interface panels exist, especially at the national level. Conflicts of interest can undermine their legitimacy or their ability to deliver on advice that can then be acted upon. Actual or perceived conflict, often due to some financial elements. So all of this goes to highlighting the importance of the right to science in the design of the science policy panel, and especially conflicts of interest. There's issues of conflict management, conflict avoidance, the transaction cost, the need to build public trust. There's a range of issues that other panelists earlier today have discussed. In reflecting on those practices, I also thought it would make sense to share with you this morning in New York. I'm here to present tomorrow to the UN General Assembly on shipping, toxics, and human rights as a special rapporteur or as a special procedure of the Human Rights Council. And so to speak about the procedures that exist at the Human Rights Council to ensure the independence and integrity of special procedure mandate holders like myself that are not conducting scientific assessment, but are similarly engaging facts and assessing facts and then reporting on them. So there's monitoring and reporting. So how to ensure the impartial assessment of facts based on internationally recognized human rights standards. That's a big one for special procedure mandate holders. And that's where there are a number of procedures that have been put in place to address actual or perceived conflicts of interest. So a couple instruments that I thought I'd mention is, one is the Convention on the Privileges and Immunities of the United Nations. Another is the regulations governing the status, basic rights, and duties of officials other than Secretariat officials and expert on mission. These, among others, I'll come back to other instruments, but these instruments, they make the point of disallowing gifts or remuneration. They make the point of disallowing having a management role or having an interest in a business if the business is to benefit from the position. There are other instruments, as I mentioned, such as the Manual of Operations of Special Procedures of the Human Rights Council that have been adopted by the special procedures themselves. So in a way, there's this process of self-regulation, and conflicts of interest have been an element in that process in the annual meetings of special procedures for many years. It is well known that mandate holders are selected on the basis of their expertise, experience, independence, impartiality, integrity, and objectivity. In order to maintain those, that's where this Manual of Operations speaks to the incompatibility with positions in government or any other position giving rise to conflicts of interest. So in that sense, it's very clear. Mandate holders are not staff of the United Nations. We do not receive a salary from the United Nations. So that process of self-regulation and the Manual of Operations of Special Procedures is further reinforced by Human Rights Council resolution that sets out a code of conduct for special procedure mandate holders. And I wish to refer to a couple elements that I think could be useful in the design, or at least in the discussion of conflicts of interest procedures and modalities for the SPP. One is to make sure that mandate holders can act in an independent capacity, free from any kind of extraneous influence, incitement, pressure, threat of or interference. So this issue of independence and integrity is really at the heart of what these procedures are intending to achieve. Another element here, neither seek nor accept instructions from any government, individual, governmental or non-governmental organization or pressure group whatsoever. Two more, refrain from using their office or knowledge gained from their function for private gain, financial or otherwise. And finally, not accept any honor, decoration, favor, gift, remuneration from any government, non-government for the activities carried out in pursuit of the mandate. These are standards, and there's a process by which the standards are given in the actual experience. So applications, for example, any person can apply to become a special rapporteur, special procedure mandate holder. There will be a process of selection. The applications include written questions on the issue of conflicts of interest. All applications are posted online. The consultative group that is established to assist the President of the Human Rights Council in the selection process, let's recall the consultative group composed by the ambassadors that are chairing each of the regional groups at the Human Rights Council. They conduct interviews, they conduct written follow-up. In addition, as I was mentioning, the self-selection, the special mandate holders have a coordination committee that can provide guidance and advice in situations where there may be situations that may emerge. And I think this is a big point as well, that determinations are on a case-by-case basis. So a couple of distillations. Conflicts of interest are not a mathematical formula. They involve considerations, valuations, weighing. They involve even judgment, appreciation. So it is a case-by-case basis. Secondly, conflicts of interest is not a one-off. It's not when a person joins a platform or a position, but it is a going process. In that regard, and this is my final point, the special procedure mandate holders have tools and standards to address the issue without external intervention. So that the process of self-selection and self-governance. Thank you very much for your attention. Happy to take any questions.
Thank you very much, Marcos, and very good to get the additional perspectives, and a number of topics also are coming back in what you are outlining here, such as, for example, the code of conduct. That was also mentioned by WHO, and this actually also brings me to some of the questions that we've been receiving during the event. I'll get back to this point a little later, but first would like to go to Jim. We received a question from Miriam Diamond of the Jeff Stab. Very interesting presentation, Jim. What could you perhaps elaborate a little bit on what you meant with the comment that the IPCC tolerates relationships with large commercial entities, but have come down heavy on SMEs? I think that's the example that you gave, but perhaps you would like to elaborate a bit further on this. Thank you.
Yeah, I mean, it's just a matter of practice. When issues have gone to the Conflict of Interest Committee, some employment with a large multinational company has been noted as a potential conflict of interest, but it's been deemed sufficient that, you know, the transparency of the declaration, and when the person is diluted within an author team that might be 15 or 16 people wrong, that the conflict, if there is one, can actually be handled in that kind of way. And it's often quite a diffuse kind of relationship because the multinationals' activities may actually be quite diverse. It wasn't a general comment about SMEs. It was we've only had this one case where somebody was involved with a startup company, and the focus of that startup company was so narrowly focused and so relevant to the question under consideration in the chapter that the conflict of interest appeared to be acute to the Conflict of Interest Committee. And I think that's the secret. It leaves me with a little discomfort because it might be seen to imply that the policy is coming harder on SMEs than on larger companies. So I just wanted you to reflect that kind of anxiety. While I've got the floor, could I just make one other observation that struck me while I've listening to the other conversations, that there may be a difference between international bodies that have an advisory function and those that have a more executive or action-oriented role. And I think the examples we've heard from the Montreal Protocol and WHO are quite different from IPCC and IPBES, which have separate mandates from their analogue bodies, the Framework Convention on Climate Change and the Convention on Biodiversity. And I think the type of people who get involved in the mandate may involve a slightly different policy. And if I could just pick up on Marcus's last talk there, he talked about forbidding remuneration for people who are involved. Well, the sad fact is that people in IPCC in the bureau roles, like say being the co-chair of a working group, can't work without pay. Somebody has to pay them. And generally that money is happening through funding, from the organization, the country that nominated them for the position within IPCC. And there are financial resources applied to support technical support units in the specific countries. And I think what Marcus has said would preclude that, but without that, IPCC couldn't operate. So I think there may be some differences to consider.
Thank you very much, Jim. And indeed, excellent that you already reflect on what some of the other panelists actually brought up. That's exactly how we would like to kind of proceed with the question and answers. We got a couple of other questions, so let's see how many we can talk about right now. Maybe in relation to the question posed related to code of conduct. Now, the question here is asked in terms of how to act when a conflict of interest is identified and impacts on independence. Does the conflict of interest policy then work in tandem with an existing code of conduct policy? I don't know, Kate, if this is a question you would like to take.
Sure, thanks very much. Yes, and I think that's a really good question. There is a difference, and I think this has come up several times, between just the identification of a conflict and sort of what happens next. So I think when going through the process before, I was speaking about, for example, in the WHO context, talking about disclosure as a really important kind of first step. So the importance of disclosure of interests, both individual and institutional interests. And then the importance following that of some due diligence to be clear about what those things are, the extent of those interests and how they may sort of fit or not fit so well in line with the interest of the panel or the policies that are under development. But also then following that a risk assessment. So as I think a number of other speakers have mentioned, it is a little bit of a case by case. There's not a sort of there's no sort of one size fits all for a conflict of interest policy, particularly, well, no, that just isn't. But essentially, a risk assessment should really look at what risks are presented by the conflict or the potential conflict that's been brought up, and what can potentially be done to avoid or mitigate those. So there can be things within, say, a code of conduct that can set some standards, set some kind of guidelines around behavior that can either be used to sort of identify the conflict or even toward management of the conflict. There are also processes and procedures that a panel, say, could have in place to make sure that as an ongoing thing, there is appropriate kind of management of any potential conflict. And that could include sort of involvement in certain aspects of a panel's activities, but not in others. You could look at say, sort of standard, even boardroom policies that require recusement of certain points where there is a direct conflict of interest or a lack of involvement in some contexts. I think I would say also that probably some of the really important things structurally around ensuring adequate kind of protection from either an actual or a perceived conflict of interest is firstly this need for very clear disclosure and the ability to seek more information if the disclosure isn't complete or if there's this further questioning, and also transparency. And I think this has come up in all presentations so far, is that there needs to be transparency in the way that the panel is governed and that it operates, that it needs to function independently of the governing body. It needs to be independent of parties and of all other stakeholders. And also you need robust processes that require transparency of data and methodologies. So for example, with WHO guideline development, all of the methodologies and all of the data on which a guideline is based have to be published. So it's all out there in the public domain. And also, in a final point, is that there also just needs to be an ongoing opportunity for independent review of the functioning of the panel and also for the advice and recommendations and analysis that it's giving. Perhaps I'll stop there in case other panelists would like to add to that. Thank you.
Colleagues in Nairobi, you are muted.
Oh, thank you so much. Thank you so much, Kate. That was very, very helpful. And I was just mentioning that actually a number of questions are coming in, and some are actually speaking to the nature of the science policy panel on chemicals, waste, and the prevention of pollution, which is currently being established. For example, in the kind of scientific field of this science policy panel, it's a bit different from the ones covered by IPCC and IPBES because of the inclusion on chemicals and toxics. And perhaps, Marcos, this is one for you to consider. A large number of the scientific data and experience are in the hand or produced by powerful private actors. So can transparency on individual researchers and experts be enough when one of the issues is how knowledge has been produced? Marcos, I don't know if you want to have a go at this question.
Thank you very much. This is a big question. Is transparency enough? Can conflicts of interest be managed effectively when the sources of information on chemicals, waste, or pollution are in private hands, in the hands of scientists that may be working in companies that have precisely conducted the analysis, the assessments, or other information sources that provide the knowledge on the issues. One thing that I would comment is that I would echo what was just mentioned, that transparency is critical, but it may not be sufficient. It involves high transaction costs, and it may not be sufficient in order to secure the public trust that's needed for the effectiveness and legitimacy of a science policy interface platform. And so when it comes to managing certain conflicts of interest, it seems to me that some conflicts need to be avoided altogether, that there are situations that are simply unable to be managed. In that sense, some conflicts may not be possible to mitigate. They should be prevented as a matter of the implications of the right to science that I was mentioning at the very beginning. Now, how to structure that in practice? We heard from the representative of the World Health Organization how certain industries or sectors whose purpose was deemed incompatible with public health were excluded altogether. Could it be possible to think along those lines in the chemicals and waste field? Maybe, but it seems difficult in any event. Could there be, alternatively, could there be a possibility where scientists affiliated with industry would have a specific role and designated as such and different from other elements of the science policy interface platform, the SPP. That could be another alternative. I've previously in other spaces spoken about the debates that have taken place at the UN Environment Assembly on how to organize public input, where scientists, for example, are, I will say, lumped together within a major groups approach, so a big tent. Now, scientists often argue they're not civil society arguing that businesses are not civil society, but all of them going together in one big bag. This in a way confuses, I would say, the channels for input. And so perhaps there's a way of differentiating the voices that are coming in with information. And so if there's a scientist or a person that is working in a company and for that reason has privileged or otherwise specialized knowledge, that there could be a role for that individual in a specific capacity that could be understood as such. That would be my take. I know this is controversial, but if I may, with your indulgence, could I come in on the issue of remuneration that was put also forward by one of my co-panelists? Is in the system of special procedures mandate holders, there's no remuneration for a special rapporteur. It is expected that the work of special rapporteurs takes about 1/3 of the time. This is an understatement. So most of us have day jobs that do not interfere or pose a conflict with the work, but that means that the profile of special procedures or special rapporteurs is quite often slanted towards academicians, and so there's not a wide variety. So this is the way that the system is set up. It doesn't mean that it has to be set up this way. I think there's a lot of discussion on whether remuneration would affect the independence or integrity of the special procedures. There's some voices that are saying we need to rethink the system. Special rapporteurs are in fact subsidizing the United Nations, the Human Rights Council, and that's not the way that it should work. In order to have a professional and efficient system, special procedures should be remunerated, and so my co-panelists made a very important point on that. Jim made a very important point on that, which I wish to echo. Thank you.
Thank you very much, Marcos. We also got a specific question to Marta, but Ashley, you're also most welcome to answer and comment on any of the other panelists' comments. The question is quite specific. Apart from acknowledging that's a very helpful and insightful presentation, Marta indicated that all recommendations are reached via consensus. She sort of came in at the end on that, which would be the preferred avenue. But are there provisions then for voting which would need to be applied perhaps in extreme areas of divergence? Would you like to comment on this, Ashley, or any other?
Sure. Marta apologizes because she's just gone to the aeroplane to come and visit you in Nairobi. We're all coming, by the way, so we're there tomorrow. Yeah, sure, there is a provision for one extreme position to be taken and to be published alongside the consensus, and you can publish it both, an exceptional opinion, if you like. And there is that, but we haven't used that in a decade, to my knowledge. There was an extreme case in methyl bromide some years ago, but since then, for the last decade, we've always come to consensus. And I must say, it's a real skill to, is to weld the decisions. And in fact, I think it's one of the great things you do to avoid conflict of interest. You manage them all. I come from an academic medicine position, and I sometimes consult for pharmaceutical companies, for example, on how to do clinical trials. you can find the amount of dollars that I achieve in 1 year on a website. So it's very clear, very transparent, and that's also present on the website. The access to that is provided on the Ozone Secretariat website. So that is a complete, it actually isn't a conflict, but nevertheless, it could be a perceived conflict. And so it's a thing that we've done in medicine for many years now, so that, people know where you're coming from. When we go to meetings, I think the declaration needs to be gone through at the beginning of the meeting for all attendees. It's all repeated and gone through. Are there any new declarations of interest? So that you're maintaining that diligence throughout. And I think by doing that, you go some places. The risk about being brutal about this, and I do mean this, is that you end up with nobody who's got any experience in the end. There are a lot of people, but they haven't got much experience in the topics you're talking about. That's so managed conflict and making sure those declarations are done and transparent is, for me, fundamentally important. I think that was what Jim was saying too, I think. Thank you.
Thank you very much, Ashley. And I will ask all of you to maybe in 30 sort of seconds at the end, give your final messages to the Science Policy Panel. It's open and a working group. I know it's a challenge, half a minute. But there's one final question perhaps that I can take. And this has to do with the case-by-case nature that has been mentioned. Considering that the conflict of interest is a case-by-case issue, there is also a lot of grey area. And how can one secure the public trust and confidence that procedures are indeed trustworthy if no clear lines in the sand can be made? Anyone? You're all thinking hard about your 30 seconds. I know, Jim, please.
Yeah. Maybe just to come in on that. But one of the things we do with the IPCC Conflict of Interest Committee is that we have legal representatives from both WMO and UNEP, the parent organisations, who also sit on the Conflict of Interest Committee to make sure that we are actually honest, and in a way that replaces the oversight of a Conflict of Interest Committee that I think Kate mentioned as well. Maybe to be efficient, if I can just use my 30 seconds at this point. One thing again that struck me about the difference between what you might call advisory bodies, of which I would say IPCC and IPBES meets the criterion, and other bodies that cover conventions, agreements, or really large organizations, is the institutional and bureaucratic capacity to actually run a conflict of interest policy. IPCC has a secretariat of only 15 people. And there are, I think it's 13 members of the executive committee who are actually elected. It's very, very light. And what that means is it's very difficult, I think, to run complex processes where you have both a conflict of interest committee and a mechanism for oversight of that committee. We just don't have the resource to do it. And that might be a consideration for a chemicals panel, depending on what kind of size of effort it has to actually back it up. And if it is separate from other institutions like the Montreal Protocol, etc. So I think to be practical, institutional capacity is also a factor.
Thank you so much, Jim. Excellent. I would like to immediately continue with the other 30 seconds reflections. Ashley, may I invite yours?
Sure, thank you. I think this is a really important topic. If you go to the Ozone Secretariat website and look under TEEP, you'll find our terms of reference, which I think are pretty tight, I would say, and have been and served us well. I think the other thing to say about the TEEP is that we do technology assessments. We do not do policy. And so we're very, very disciplined about not recommending one policy or another. We say, if you did this, that would happen. If you do this, that might happen. But we restrict ourselves. The parties make policy. So I think that in some way protects us. But We're really disciplined about that. But have a look at at the terms of reference. I think Marta did a great job, by the way. Thank you.
Excellent. Thank you so much. And also our thanks to Marta, of course. Kate, any final reflections or good advice for the Science Policy Panel?
Thanks. Yeah, look, in 30 seconds. I think just to emphasize that it is important to bring it back to the role of the panel, like what it is that you intend the panel to do. The ways in which potentially the panel's work might be impacted by conflicting interests and the ways in which it might appear to be. And to then bearing that in mind, I guess, to consider which actors you might engage, which role for which policies and in which phases of the policy cycle. So not to take too kind of in or out or too blunt an approach to it, because as I think has been mentioned, there are ways in which there are important roles to play from different actors. Sometimes those engagements, those sort of conflicts can't be mitigated. Examples have been given. But in other ways, perhaps they can be managed just through the process. But yeah, I think just to bear in mind the diversity of the stakeholders perhaps that you're considering, as well as potentially the policies and the outputs of the panel that you intended to produce. Thank you.
Thank you very much. And I think again, great advice to the panel. So last but not least, Marcos, over to you.
Thank you very much, Chair. So looking back on the road to the UN Environment Assembly that decided to move forward with an SPP, we can recall that there were voices that expressed concern about a new platform that could be captured by industry. And in that regard, I would wish to highlight that conflicts of interest and addressing them and dealing with them effectively is the best antidote to that possible capture. And here, unlike the situation that would have been maybe decades ago, there's a wealth of experience to learn from, and so the lessons learned, the good practices. Sure, there are differences in the chemicals waste and pollution sector, but there's a lot of experience that can be used to build a robust and effective conflict of interest mechanism. Thank you very much.
Thank you very much, and my sincere thanks to all the panelists for very generously sharing your experiences, your learnings, and also thinking across, identifying the differences and the similarities. It's been very rich discussion and I think very, very helpful. So thank you so much for all your inputs and contributions. Also thanks to the chair of the Open Energy Working Group for being with us, and thanks of course to the Geneva Environment Network. Colleagues, everyone online, it was wonderful to interact with you on this. It's a very important topic. We have lots of takeaways from it. So thank you all very much for active participation, and have a good day. Thank you, everyone. Bye-bye.